From a woman who turned family disputes into full-blown assaults and theft.
Jackie proceeded to strike me in the eye with a water bottle at close range, putting her hands up, blocked punches, throwing. Her boyfriend kept trying to grab my hands. He continues to target my business, my whole life. List goes on, Your Honor.
To another facing charges after waiving her preliminary hearing.
Ms. Vaughn, you understand under Michigan law, you have a right to a preliminary examination.
Yes.
And you understand at that hearing, the prosecutor would have to show that a crime occurred and probable cause exists to charge you with that crime.
Yes.
And are you voluntarily waiving your right to that preliminary hearing?
Yes.
These cases show just how far some will go and how the court holds them accountable. Starting with Ms. Taylor's case here, we have a woman facing charges for her reckless and violent behavior, from physical attacks and theft down to social media harassment. Let's see how the judge handles this.
Ready, Your Honor.
All right, great. Good morning, Mr. Bogart.
Good morning, Your Honor. Always good to see you.
All right, this is 242116SM, the People versus Jacqueline Taylor.
And good morning, Your Honor. Again, David Bogart appearing on behalf of Ms. Taylor, who is present standing to my left. Ms. Taylor, please tell the court your full name.
Jacqueline Marie Taylor.
All right, good morning, ma'am.
Good morning.
All right, so it's the time and date set for sentencing as to the report, counsel.
Your Honor, I've had a chance to read the PSI and go over it with my client. I find no corrections, additions, nor deletions, with the exceptions of a few things. As far as employment goes, at that time that this PSI was done and interviewed with the probation officer, Ms. Taylor has secured a position for employment, and that is in Toledo, Ohio. And other than that, and she recently sold her home and is planning on moving with the court's permission, of course. But other than that, there are no corrections, additions, deletions, besides of what I said, and elocution upon the court's convenience.
Okay, is anyone here? John Hodge?
Yes.
All right, Mr. Hodge, if you can come up to this microphone here on the table. Sir, it's a time and date set for sentencing as a complaining witness in a case you have a right to make a victim's impact statement. Is there anything you want to tell the court?
Yes, ma'am. Your Honor, in the interest of the court, I want to state briefly the facts of the criminal action Jackie Taylor has on me since it was committed. I can remove all the physical damage and attacks by Jackie and her boyfriend, Cody James Karen, and were brought to my place of business, told me not to come on the property for any reason. Jackie proceeded to strike me in the eye with a water bottle at close range, putting her hands up, blocked punches, throwing. Her boyfriend kept trying to grab my hands. I am a grown man with physical damages, and I get past. But Jackie's behavior leads to this incident shows no remorse. She continues to target my business, my whole life. List goes on, Your Honor. I'm sure you had a chance to look over things before and assault me at my business. Your detective team has deemed over $300,000 Jackie stole from my business. It was sitting downtown on a hearing. Since then, I has come to my business, screaming out windows, beeping, yelling obnoxious things, bringing people to my business, attacking me, stole items from my shop while doing insulting and trashing me on my business, social media, reaching out to my clients, trying to take over my accounts. As a result, breaking and entering charges on my cottage. The Taylor police were supposed to ask Roscommon sheriffs to reach out to threatening occasions. I wish no harm for Jackie. For the sake of her community, myself, my grandchild, Jackie's daughter, something needs to be done. I personally feel drugs, untreated mental issues are self-medicated, played a big role in Jackie's hostile behavior. I put her out a big drug problem years ago. I was her biggest fan.
Calm down.
Okay.
You have your 1 second. Your attorney has a chance to allocute on your behalf.
Yes.
He has a right as a victim to make a statement. Just take the drama down. Let him say his piece. He's got a right to do that. Go ahead.
Thank you, sir. I pulled her out with Dick Props some years ago, and I was her biggest fan a couple of years ago, but she started to go back down that path, taking everyone down with her, and I'm not that person who will help her at this time. One thing I can tell you, Judge, is that I do not something done for her today. I feel for her well-being and everyone around her. Thank you very much.
Thank you, sir.
You're welcome.
All right, counsel, or you or your client have anything to say?
Yes, Your Honor. My client's daughter would also like to make a statement if the court.
How old is she?
15.
Okay.
She has a letter in there.
It's up to you, Your Honor.
I mean, she's not a complaining witness. I don't know that she has a right to speak at the hearing, and I don't want to, then the complainant or the victim might have someone else that wants to speak, and the next thing you know, it's out of hand.
Your Honor, I just
Or
thought I'd
even-
mention that to the court, but I just have a brief elocution and then Ms. Taylor has something to say.
Okay,
I love my father.
No, not yet.
let Mr. Bogart speak first.
Thank you, Your Honor. Your Honor, I'm not here to rehash and retry the case, as the court is aware of what attorneys' roles are in this. I know for a fact that Ms. Taylor certainly regrets the incident, her decisions that she's made that day. There was a strong family dynamics, as this court is acutely aware, between Jackie and her father and her daughter and grandfather. Your Honor, she's grateful for the 769 4A. And I have seen the video, and again, I'm not going to rehash it. I think there was a lot of blame to go around with everybody in this case, but I think this resolves the case in the way that it should be resolved. And I would ask the court to adopt the recommendation. Thank you.
I love my father. He was my best friend. He did save my life when I was an addict. I lost my job because of his girlfriend being one. I had to save myself. It's hurtful. My daughter's going through it. I'm just taking myself completely out of the situation and moving to Ohio. I'm a locksmith. I do very, very well at it, and I love my job. If the court allows me to move to Ohio, it's gonna diffuse the situation. That was my
Do you have
best.
housing there?
I'm going to look today. I can get some. I'm selling my home and cash sale quick, so I can. I live 0.5 miles away, ma'am. I love that man. I fixed his business. I gave him everything, 8 years, 24/7, 7 days a week,
Well,
And
it's
yeah,
unfortunate.
it is
when
very
fa-
unfortunate.
family things like that happen, but it's not I'm here because there's a conviction at this point on domestic violence, and I'm sorry that the two of you are unable to work out your differences.
I wish we could. That's what I really wish we could, but
Your Honor, I'd like to give the court a little bit of clarity.
Time heals all wounds.
Just so the court has this clarity, I also did her divorce, and in that divorce, she was awarded the house. She's recently accepted a cash offer on the house. The paperwork hasn't gone through yet. It was just recent, and she recently accepted a job in Toledo, and that's where it's at, Your Honor. So just so the court's going, hey, is there housing? Is it that's what's happening. So
Okay.
I didn't mean to jump
No,
in.
I
but the
just-
court needs to know that. If there's anything else, please say it. If not,
it
then
hurts my
let the
daughter to
court.
have to see all the things that happens to, her ex-boyfriend got a car. I'm struggling. I just went through a divorce. He gives my ex-husband jobs, and he was a abuser in a case that we just had with a child. So it's very hard as a mom.
The ex-husband, not Mr. Hodge.
Yeah, we had a case with my child, and I know, and it's hurtful. She needed her grandpa. She don't have a dad. Her dad's a heroin addict in jail now. 13 years he raised her. That was his everything. I was too. I'm so sad, but they can get better. I want it to get better, but
Well, I think some distance is probably a good idea. Look, you don't have a prior criminal history,
I'm
but you
I'm a
did,
victim.
not today, you're not.
No, not today. No.
Okay, listen.
The court speak.
Listen, I've heard both parties. I think it's really unfortunate. But that's, I'm not a counselor, so, I've got a criminal case in front of me. I know that there's no criminal history. It's a first offense. You were given a 7694, which is a diversionary status. The plea was for 12 months probation. So you'll do the 12 months of probation because it's domestic violence. So the early termination would not apply. All right, but it can convert to non-reporting at some point if you've complied with all of the terms. You have a fine of 50, court cost of 50, state cost of 50, and a crime victim's rights fee of 75. You have a probation oversight fee of $450, and community service is $10 a day for a total of $50. You'll do 12 months probation. You'll complete 5 days or 40 hours of community service in the city of Taylor as directed by probation and provide proof. You're to abstain. Yeah, you're abstaining from the use of possession or alcohol or controlled substances unless prescribed by a physician. Documentation will be required, and that's for the term of your probation. And you will have drug and alcohol testing as deemed necessary. That will be at your expense, but testing will likely be on demand. You're to submit to a substance use of. Are there allegations of
No.
drugs or alcohol? No, I'm
No,
not
not on
talking.
this one, no, Your Honor.
No drugs or alcohol
None.
involved in this? All right. I'm taking out the substance use evaluation. There's no indication that drugs or alcohol were at issue in the case. So you'll complete anger management as directed by probation through better choices and provide proof. Okay, you'll attend and complete any ancillary services deemed warranted. You'll stay out of establishments where the primary purpose is the sale or service of alcohol. You're not to have any contact with John Hodge, okay? And if that ever needs to be changed over the course of the next year, we'll conduct a hearing when both parties are present. And if anybody wants that eventually converted to non-assaultive, if things do lighten up, that's always an option the court would consider. You're to seek employment and provide proof. You've done that. You cannot drive without a valid license. Your sentence is deferred under 7694A. And were you printed at time of arrest?
I came into it.
You did do the printing? Okay, then you're all set.
Thank you, Your Honor.
All right, have a good day.
You and your staff have a good day.
It's outrageous how some never learn. Here we have James Moses, back in court after getting caught for his second drunk driving offense.
James Moses, 243154.
Morning, I'm James Zick on behalf of Mr. Moses. He's here for sentencing, gone over the sentence report, no additions or corrections. Your Honor, as to the recommendation on the probation, this matter happened back in 2023 in June. For unknown reasons, it was not brought to this court and initiated until December of last year. That's 18 months. Mr. Moses has had no problems or anything. His assessment is he's low risk, minimum, low supervision or minimum supervision. I'm asking the court to possibly amend the length of the probation in this matter.
Okay, here's my concern. It's a second. It's not a first drunk driving. If it's a first drunk driving, he might not even need probation. But my thought is you drunk drove once and you got in trouble, you got caught. That's supposed to be the wake up call. You don't drunk drive anymore. And then you did it again. So I think probation is appropriate because clearly you didn't learn anything the first time and you're going to the second time. And I recognize the BAC it's over the legal limit, but it wasn't egregious. But you're eligible for termination of your probation at the halfway point. So they're recommending 12 months. You could be done in 6. And some of the things I think you do need to do. And it's largely just because it's a second offense, and that tells me you didn't learn anything. And you're going to kill somebody, and you're not going to do it on my watch. I'm not going to look back on if I just give you fines and costs and you walk out and you didn't get a consequence for this, you're going to do it again. Next time you kill somebody and I have to deal with that. I'm my conscience and I'm not.
Your Honor,
So go ahead.
I'm so embarrassed about this. So yes, I apologize for wasting your time.
You're not wasting, I mean, this is my job, but you understand why to a judge this would be, and I understand the first one was years ago.
It's 2010, right? And I was told that I should have had that removed, but okay.
I mean, but now we're here, and we still would have seen it.
Correct.
I mean, it becomes a non-public record, but a court can still see that.
So I definitely learned my lesson, Your Honor.
All right, well, you're eligible for termination at the halfway point, and if you've done the things that you need to do, you'll be all set. And I've noticed they're not requiring that he go to the guidance center or someplace else for treatment. They're recommending he takes a class. So, Sir, you have a fine of $300. I am amending that. Court costs of $300. You have state costs of 50, crime victims' rights fee of 75, probation oversight fee of $450, community service fee of $10 a day for $50, and an assessment fee of 50. So your total is $1325. The recommendation from probation was 12 months of probation, again, eligible for termination at the halfway point. You'd, under Michigan law, you'd complete 5 days with 40 hours of community service in the city of Taylor and provide proof. You would abstain from the use or possession of alcohol or controlled substances unless prescribed by a physician with documentation. And that'll be for the term of probation with random drug and alcohol testing is deemed necessary. The testing will be at your expense. You'll complete a weekend alcohol education course as provided by probation through ETRS and provide proof and follow recommendations. You'll attend the victims impact panel and provide proof of completion. Stay out of establishments that primarily sell and serve alcohol. Any other ancillary services that may be deemed warranted will be required to complete. You'll maintain employment and provide proof, no driving without a license, and obtain an order for fingerprints. And a lot of these are easy things. I mean, they're things you're already doing, or there are things, you know, that you attend a weekend class, you attend a victims impact panel, you can complete all of this in 6 months. Okay, and you can have a payment plan if you need it for the fines and costs.
Okay,
All right,
Thank you, Judge.
thank you.
that sounds nice. Thank you, Your Honor.
All right, have a good day.
I have one more question. I think we talked about it. I'm a manager over a department, I'm IT. I have to go to work at the airport, like crazy hours of the night if anything happens. How does that impact my driving? Because I got my license, but it's
Restricted?
restricted.
If
yes.
you're I mean, it should be restricted by what you're doing, not the hours. I mean,
Okay.
it should say on it, I've seen them with hours before, but not without a hearing. Normally it says you can drive to and from work,
Okay.
medical, schooling. You'll have to look at the actual restrictions on your license. As long as you're going to work, it doesn't matter what time you're going.
Okay, all right, perfect. Thank you so
Yeah,
much.
Your Honor, for the record, I did tell them that Secretary of State regulates license, court
Yeah.
has no jurisdiction, so.
Yeah, so I mean, you have to check them, but I can't modify the restrictions.
So-
But generally, if it says to work, you're going to work, whether you're going to work at 2 in the morning or 8 in the
Correct,
morning, you're
yes.
going to work.
Yes, yes.
Okay.
Change controls and everything. Yes, all right.
Yeah.
And
All
also, I recommend you get a stand. Look like you got one.
I have one.
I see the book still.
I know, I'm working.
Unlike Mr. Moses, who recklessly put lives at risk, Ronald Smith's case is all about getting his life back on track through rehab instead of just punishment.
All right, we're back on record on Ronald Smith. Counsel's present, Mr. Smith is present. Counsel, did the two of you have an opportunity to go through all these documents?
Yes, Your Honor.
All right, and Mr. Smith, do you understand everything you signed here today?
Yes,
And you had a chance to go over it with your attorney?
yes,
Okay. So you've signed a waiver of right to assert specified grounds for basis and motion of refusal, right? And you understand what that means? You want me to? Okay, I'll give you just a real quick one so you understand. If I'm your judge of record in a treatment court program, I might know more about you than, you know, in a standard probation would. And you can't say, well, you know me, so you can't handle my case anymore because of that, right? Because that's kind of the goal of a treatment court, is that we have some sort of relationship with each other to help you with your recovery. Make sense?
yes,
And then you've signed the you've signed the form for admission into the treatment court program, and I'll sign that as well. And you have a pretty good understanding at this point of what the expectations are, right?
yes, Your Honor.
And you're really seem to be doing a really good job so far, so that's good. And then the treatment court program agreement, you signed and executed this as well?
Yes.
All right, good, we're good to go. I've read the pre-sentence investigation. Counsel, is there anything with respect to the report that you want to discuss? Or,
Your Honor, no additions, corrections, deletion is factually accurate.
okay, anything you want to say by way of allocution, either of you?
Judge, he, like you indicated, was doing well, we just asked the court to follow the recommendation of probation department.
Perfect. Okay, great. All right, you have a $100 alcohol assessment fee. You have probation oversight fees of $900. You have $500 program fees and $20 clinical oversight fee, and that's for $1,520. And I'm assuming that you were assessed fines at the court that you're coming from.
Yeah.
Correct? Okay. You can have a payment plan to pay at this court. You pay at the rate of $126.67 per month, and that would start on a month from today on March 19th. You would enter the treatment court program for a period of 18 months and follow all requirements listed in the participant handbook. You'll attend and complete substance abuse treatment and follow all recommendations of the therapist at the guidance center. You'll attend 3 pro-social meetings per week as directed by probation and provide proof. You'll obtain a sponsor within 60 days or a mentor. You'll submit to random drug and alcohol testing as directed. You'll abstain from the use or possession of alcohol, controlled substances, or paraphernalia. No prescription or over-the-counter medications without prior approval from the probation department. Okay, you'll have a scram for 90 days, and that started on January 2nd of 25. So you'll just have that for the remainder of your term. You'll follow all steps outlined in the individual development plan that you'll write in phase 1. And any additional programs that I deem necessary as a treatment court judge. You'll remain out of establishments that primarily sell and serve alcohol. You're not to enter areas known for drug use. You cannot surround yourself with drug and alcohol using peers. Any other ancillary services that may be required, you'll be required to complete. You have 100 hours of community service in the city of Taylor as directed by probation and provide proof. You'll complete the victims impact panel within 60 days. You'll attend the alumni meetings while in phase 1. You'll clear all outstanding warrants over the course of your probation, and no driving without a valid license. So that seems like a lot, right? But most of it you're already doing. So, all right, you're all set. Welcome officially to the program.
And judges, you go back down to probation department?
Yeah, he should be able to set up his appointment for orders if he just goes downstairs. And that way he doesn't have to wait for mail.
All right, thank you, Judge.
Yeah.
Good seeing you.
Good to see you.
Now we have Mr. Mahome, who had one job, completing his anger management course. But instead of getting it done, he keeps giving excuses. Let's watch this.
This is 240004, the People versus Paul Mahone.
Morning, Your Honor. James Kazik on behalf of Mr. Mahone. Down in this matters before the court for review. Original agreement was supposed to be dismissed after he complied with the court's instructions. My understanding is that he has enrolled into the course that he was supposed to enroll in, anger management. He didn't do it sooner. It was a money problem, and but he's supposed to start up in March.
Well, I have that he booked it for March 24.
Right.
Correct? Well, I'm not letting him off until I get
Right.
the certificate.
Right.
So you must have the certificate to us by the end of March. I'm not going to do any extensions. You need to make sure you make the class, you complete the class, you get the certification, and you bring it up to probation by the 30th. Okay? And
It's an 8-week course, I think.
Oh, this one?
he's
is-
the
Oh, this
weekend.
one's a short one.
Short.
Oh, okay.
Yeah, it's a weekend
Okay.
class. So you have to get that to me and to the well, don't bring it to me, bring it to probation right away upon completion. And then we can just, if a hearing's necessary for the prosecutor, we'll have one. Otherwise, we'll just, the prosecutor will dismiss the case. But I need that paperwork.
My understanding that they're communicating directly with the probation department, so.
Well, you communicate with the probation department, right? And they'll talk to whoever they need to talk to. But you make sure that you're communicating and you get that to Ms. Wagaman, okay?
Okay.
All right, you're all set.
Thank you, Your Honor.
Okay.
Finally, we have this last one on Ms. Vaugh, focused on a normal routine waiver of her preliminary hearing.
This is 250100, the People versus Tanisha Vaughn.
Yes.
Good morning. Can I get appearances?
Yes, good morning. Benita Hoffman, Assistant Attorney General on behalf of the people.
And good morning, Your Honor. Brian Gagnick with Neighborhood Defenders Service, P64220.
All right, so it's the time and date set for the probable cause conference. What is the status of discovery?
Your Honor, I have everything that I need. We're looking to ask the court to accept a waiver of our preliminary examination this morning.
Okay. Any objection from the people?
No, Your Honor.
All right, can I voir dire your client, counsel? All right. Ms. Vaughn, you understand under Michigan law, you have the right to a preliminary examination.
Yes.
And you understand at that hearing, the prosecutor would have to show that a crime occurred and probable cause exists to charge you with that crime.
Yes.
And are you voluntarily waiving your right to that preliminary hearing?
Yes.
And if you had a chance to discuss this with your counsel?
Yes.
And do you understand that you'll be bound over to the Third Circuit Court for all future proceedings? And you'll be bound over on all the charges in the complaint and warrant?
Yes.
Okay. Can I, Mr. Gagnon, can I sign your name with permission?
Yes, of course.
Ms. Hoffman, can I sign your name?
Absolutely, Your Honor.
And Ms. Vaughn, can I sign your name on this plea form? Or I'm sorry, on this waiver form?
Yes.
Okay. You'll be bound over to Wayne County Circuit Court for future proceedings. The date of the arraignment on the information
Wednesday, February 26th.
will be Wednesday, February 26th.
Okay.
Thank you, Your Honor.
All right, everyone, you're all set. Have a good day.